The Supreme Court has upheld the constitutional powers of the president to declare a state of emergency in any state to prevent a breakdown of law and order or a descent into chaos. In a split 6-1 decision, the Apex Court ruled that the president may, during a state of emergency, suspend elected officials, provided such suspension is for a limited period. Delivering the lead judgment, Justice Mohammed Idris held that Section 305 of the Constitution empowers the President to deploy extraordinary measures to restore normalcy, noting that the section does not specify the nature of such measures, thereby granting the President discretionary powers. The ruling followed a suit filed by Adamawa State and 10 other PDP-led states, challenging the emergency rule declared by President Bola Tinubu in Rivers State, during which Governor Siminalayi Fubara and other elected officials were suspended for 6 months. While the court struck out the suit for lack of jurisdiction and dismissed it on the merits, Justice Obande Ogunya dissented, ruling that the president cannot suspend elected state officials under emergency powers. And joining us via Zoom to discuss this is a legal practitioner, Mutiu Akinsoya. Hello there, Mutiu. Good evening. Thank you for joining us.
Good evening. It's my pleasure to meet you this evening.
Okay, now, how far can the president go under Section 305 of the Constitution when declaring a state of emergency? And what safeguards exist to prevent abuse of this discretionary power?
Yes, so the Supreme Court has spoken. The president can go as far as one can imagine. The essence of an emergency rule is to ensure that there is no complete breakdown of law and order. And whatever the president in his own discretion thinks is the best way to maintain law and order, the president can go as far as he thinks or as far as his discretion can accommodate. But for me, the only check to the president's powers is the National Assembly. And until we have a very robust National Assembly that can help to checkmate the excesses of the president whenever issues of states of emergency arises, the president's power may continue to be unfettered. So the National Assembly is there to always check. And one will expect that if this happens in future, that the National Assembly should be there to check whatever excesses that may be contained in whatever proclamation the president issues in respect of a state of emergency.
Now, okay. Now, does this Supreme Court ruling alter the balance of power between federal and state governments, particularly regarding the suspension of elected state officials?
I don't think it does. Looking at this ruling, the ruling that the Supreme Court delivered today, the Supreme Court was not given the opportunity to make this decision based on facts. And the reason is because the Supreme Court itself held that it had no jurisdiction because all of those states that appeared before the Supreme Court were not states that were affected by the emergency proclamation made by the president. What one would have expected is to see River States in the midst of this litigation. But River State was completely absent from the litigation, and all of the states that were before the Supreme Court were states who do not have the locus standi. There were states that were not directly affected by that proclamation. And I'm sure that was why the Supreme Court declined jurisdiction, because they had no cause of action. And even in dealing with the merits of the matter they brought before the Supreme Court also could not place its decision within the facts that were available in what happened in Rivers State. So I'm sure the Supreme Court only looked at Section 305 and decipher from those provisions that the president can make those proclamations and the president can go as far as he wishes in making those proclamations. If you look at Section 305, Section 305 also allows even a governor to make submissions to the president to declare a state of emergency in his state. Of course, that was not the case in the case of Rivers, but what that means is that there is still a balance. The intention of the law is to ensure that there is no breakdown of law and order, and that when such may happen, the president can use his discretion to ensure that there is no complete breakdown of law and order, and that things can still run the way they should run within any state across the federation.
Okay, now, given the court's dismissal of the suit for lack of jurisdiction, what legal options do states have to challenge a presidential state of emergency in future?
Yes, we will have to wait until that future comes. Okay. In this case, like I said, the Supreme Court was not given the opportunity to make its decision within facts that were present in Rivers State. What we expect to see in the future is a situation where states that are affected are bold enough to challenge those powers of the president before the Supreme Court. And one would have expected that Rivers State, that is directly affected by this state of emergency, should have been the state before the Supreme Court, and not other states that were not affected by that proclamation.
Okay. So thank you very much, Mitio Akinsoya, for your insight. We really appreciate your joining us this evening.